In this video, we're going to talk about 6 different ways that you can make sure that, upon your passing, people aren't squabbling over your assets and fighting over things, that everything goes to the right person, and there's not conflicts within the family. So the first way that we're going to go over doing that is just your regular estate planning approach. Before starting with estate planning, it's essential that you make sure that you have a full inventory of all the assets that you own, the different structures that own those assets, and understand which laws are over all of those assets and where you've established them. And so it's often most effective if the entire family also participates in this discussion when you're working through who gets what. That way they feel like they've had a say, you gave them justification as to why they weren't getting certain things while you're still alive, and it's not a problem after you pass away. And again, second to just estate planning, you want to make sure that you're assessing all the different laws within the jurisdictions and procedures for how that'll work. If you're working with a good estate planner, it's likely that they've established, multiple types of trusts, and we'll talk about this later in the diversification portion, but with the multiple types of trusts, they also might be in different jurisdictions globally, and they might hold different assets. And so the laws that govern that jurisdiction might be favorable for taxes, but there's also going to be some other caveats and details along with that for the distribution of those assets upon your passing. So you just want to make sure that you're aware of all those things and asking those questions when you're setting those things up with your estate planner. Another way that you could resolve conflict without any litigation would be family governance. And if you have a documentation for that, we work with our clients to establish that here at Digital Ascension Group. But within that documentation, we can have a dispute resolution, and that can basically help the family resolve conflicts if there are any outside of the courts, which is going to have a much more favorable outcome. You're not going to have to spend money from the family on litigation and burn through resources that you might have otherwise distributed. You want diversification in your estate planning process. And to ensure diversification in estate planning, different vehicles mitigate different types of risks. Holding everything under one vehicle, which I've seen before, you might have one living trust that is irrevocable or revocable that holds all the assets of the family. That could get tied up in court. If one of the heirs disapproves, there can still be litigation against that, even though one of the main reasons people set trusts up is to avoid the litigation process or a probate upon their death. If family members are jaded or contest that, if things aren't siloed out into different verticals, which are going to pass to each part of the family, then they can still tie things up in court. So we don't want that. You're going to have trustees that are going to make sure that things are allocated correctly. If you have an asset protection trust or other types of trust, and again, that depends on the jurisdiction. Another consideration that you might look at when forming trusts in different jurisdictions is the type of law that's practiced in that jurisdiction, whether it's civil law or common law. And you want to make sure that you're establishing things in jurisdictions where the laws are cohesive and not at odds with one another. A standard practice that you might see, and I've seen, is to include a no contest clause, which penalizes any beneficiaries for attacking the trust by revoking their beneficial interests. So if you're going to come back at the family and you're upset about what you got and you do bring litigation, the clause in that states that you're just removed completely from your allocation or distribution. And then you also have, other jurisdictions in the world have alternative dispute resolution laws. One of those is in Liechtenstein, and it's possible to have a compulsory alternative dispute resolution via arbitrage instead of in the public courts. And so, that's probably not common, but at least in Liechtenstein and maybe some other European countries, you might look into that if there are conflicts that arise after your passing. So hopefully this has been valuable for you. Those are 6 different things that you can look at when you're setting up your estate plan to kind of limit your exposure to having litigation or fights or conflicts between the heirs in your estate. If this was valuable for you, please like, subscribe, and we'll see you guys on the next one.